If you're in Illinois and you're facing suits, who are you going to call? Dan Saeedi. He's a bona fide BIPA-buster with the Biometric Privacy Team at Blank Rome, with more than 50 biometric privacy cases under his belt. I'm Joel McConvey, and on today's Biometric Update Podcast, Dan Saeedi gives us his view on Illinois' Biometric Information Privacy Act.
My name's Dan Saeedi, and I'm a partner at Blank Rome in the Chicago office. And my practice really focuses on technology, a lot of work regarding privacy and privacy class actions, including biometrics, and also litigation across a variety of other technological topics and types of work. So intellectual property, technology contracts, data, software, those kind of things. But privacy and biometrics is definitely a core of the practice and of my interest.
And, we're here effectively to talk about BIPA and to sort of dig into some of the Illinois' biometric privacy law and some of the encounters you've had with it in your capacity as an attorney. So BIPA has been a bit of a thorn in the side for some organizations. For others, it's been a bit of a I don't want to say cash cow, but certainly something that people look at and go, well, maybe there's an opportunity for litigation here. So you have a pretty close relationship with this law. Can you tell us, give us your perspective on BIPA and tell us sort of how you've been involved with it in the courtroom?
Sure, happy to. So the Biometric Information Privacy Act, it's really unique across the country for a variety of reasons. But the most prominent one is that it allows for a private right of action that can be filed in civil court, and that has spurred a significant amount of litigation. There are other jurisdictions that govern biometrics by statute. Some of them do not allow private rights of action, but instead allow for attorney general enforcement. There is a growing trend to allow for certain types of governance regarding biometrics, and maybe even in certain sectoral areas to allow for private rights of action, but it's definitely the exception and not the rule. But Illinois is different. Illinois statute is broad, it's potent, and it's all-encompassing in terms of biometrics, and it has created a significant amount of litigation since it was enacted in 2008. And by a significant amount, I'm talking about thousands of cases that have been filed across every industry in Illinois that has ever interacted with any version of technology that constitutes biometrics or collects biometrics. And so it's had a profound impact on the industry in Illinois and also on how we advise our clients to comply. My experience with BIPA started in 2018, 2019, and that was when I got my first case. And it ended up being a landmark case because it involved class actions under the biometric statute involving railroads. One of those cases ultimately went to become the first jury trial, and I represented the vendor to the railroad that was sued. And so the lawsuit pointed the finger at the railroad pointed the finger at us. Ultimately, the railroad was found to be liable in the direct case. And ultimately, our client escaped liability across the different cases. And it was a good result for our client. And at the same time, I think it was the right result. But it was a very interesting case. It had a lot of moving parts, and it had a lot of precedential value across a variety of issues that have now, continued to come up under the statute. So since then, I've handled I want to say hundreds of cases and consultations across a variety of topics. And the cases continue to come, maybe not at the same proliferation that they used to, but they're still coming, and they're coming across a variety of technologies. And so as long as technologies continue to use that type of biometrics component, there's going to be litigation, and I'm going to continue to practice in that area.
Can you give me your opinion or your insights on why you think Illinois' law, why has the state chosen, or why did it choose to go this route and create the private right of action that allows for these class actions to take place?
Yes. So in the United States, there isn't an overarching privacy regulatory scheme. It's more sectoral, and oftentimes it's left to the states as their own petri dishes for exploring how to deal with certain sectoral privacy rights. Illinois was at the forefront of this early on in terms of recognizing that biometric technology has obviously its benefits, but it also has a potential cost in that, as the statute says at the beginning of it, once a person's biometric print is compromised, it's not like they can go ahead and change their biometric, print or their bodily, permutations. That is something that is permanently compromised. And so there was this fear amongst the legislatures that this is something that could potentially be a problem. And I think what spurred it was there was a supermarket that went into bankruptcy and was potentially selling data that was collected. And there was a fear as to the transmission or even the sale of data without consumer consent. And so that's where the statute, I think, came from. And so I think it was certainly born of good intentions and still continues to have that. Reasonable minds can differ as to whether it is the appropriate amount of deterrence or whether it's too much of a deterrence. But it was born, I believe, of good intentions.
It was, correct me if I'm wrong, but it was curbed maybe a couple years back. Is that right? There was some limit put on the number of violations that could be sued for. I recall hearing that it was like, one person, if they had their biometrics taken and there was a violation of BIPA, then it's not like they could pursue a case for every single violation in one instance. But you would know more about this than I do. Does this sound remotely correct?
Yes. So the way that the statute was written, and surprise, surprise, when statutes are written by legislatures, it doesn't always capture the realities of life and how technologies actually work. So before I even get to the statute, obviously when we're talking about biometric types of technologies, these are things that are going to be focused on capturing data related to retinas, face scans, face geometric scans, handprints, fingerprints, voice prints, those types of measurements. And the idea was that, those are the things that can't be changed, and those are your permanent features of your body, and we don't want them being compromised. The problem was that the statute was a little bit unclear as to what constitutes a violation, mm-hmm. and whether a violation is one time for each person as they use the device repeatedly, or a separate violation for each scan that's taking place. And there was a real controversy regarding that, and it got litigated, and it ultimately made its way all the way to the highest court in Illinois. And there the court said, we interpret this as a violation per scan under the statute. And potentially it could carry its own damages model. The court didn't say that it automatically did carry its own damages model, but it was interpreted as its own individual violation. Well, that creates a problem, right? Because now are we talking about a predictable damages model or something that is unwieldy and maybe even catastrophic? What the court said in its wisdom was, if this is a problem, we invite the legislature to fix it and to clarify its intent. And I believe they actually said the word, make clear its intent. 6 months later, the legislature did, and they passed an amendment. And interestingly enough, in their legislative history, said, we're making clear our intent by passing this. And so we thought that the two bodies were communicating with each other very well. And the amendment said, we're going to look at this as, treat it as a violation per person and not these separate violations, where it's a technology that's repeatedly doing the same thing. In other words, BIPA is still potent, but it's predictably potent. It's not astronomically potent.
Right.
There was a big controversy as to whether the legislature's amendment was going to look backward for all the cases that have been filed, or whether it was only looking forward. We call it the retroactivity fight. It was litigated significantly across a lot of lower courts. Most of the courts, and by most I mean all of them except for one, held that it was not retroactive, which was a really not good ruling for businesses. The only one that went the other way was the ruling that my firm and my team obtained saying, no, it is retroactive. So we had a 1 versus, 30 type of scenario, and it made its way to the appellate courts. And the Seventh Circuit has just recently, I think in the last couple of months, said, no, it is retroactive and it looks backward. So what does that mean? The law basically at this point, we look at it as more predictable in terms of a damages model. And I think something that can be actually dealt with as opposed to astronomical damages. Now, are people going to continue litigating that? Will it go to the Illinois Supreme Court? BIPA creates a lot of litigation, and I imagine that at some point the Illinois Supreme Court will weigh in on that. But for the time being, the law is, and I'm biased because I represent the defense side, but I believe the law is where it should be.
Okay. Given all of this change and sort of overall, has litigation been consistent? Have you seen any dips or changes in sort of the volume of cases you're getting?
So initially, there were some landmark cases that were filed in 2018, 2019, testing out different theories, seeing where BIPA started and ended. Then we saw a significant wave throughout COVID in terms of filings. And many of those filings focused on fingerprint scanners. There were other filings that focused on facial scans, automotive facial cameras, building cameras, optical technologies on websites that measured your face for products, voice print cases. There was a while where the floodgates were really open, and there could have been as many as 10 filings a day under BIPA.
Wow.
That has diminished. There are still filings, usually every day, but not at the frequency. And I do think that's a function of the lower hanging fruit cases having been filed and dealt with, and now more of a focus on potentially larger cases, maybe cases involving artificial intelligence, maybe cases involving new products, new technology deployments. And so I think there are still cases. It's not as frequent, but it's potentially more potent.
That's something I wanted to ask, actually. When this law was created, biometrics were a certain thing, but with AI and deepfakes, it's really kind of changed the landscape in terms of what it means if your biometrics are out there. Has AI shaken things up from a legal perspective as well in terms of how you see BIPA and other laws sort of evolving?
Absolutely. I think the AI revolution is still in its infancy. And one of the reasons why I know that is because our practice, even as lawyers, is being impacted by artificial intelligence. I want to say even on a monthly basis, where every month there's more and more of an emphasis on AI and how it actually interacts with our daily lives. And so I've always said to my team, this is in its infancy, and where we are now will be different than 12 months from now and 24 months from now. What I think will make it interesting is how AI and AI products will potentially interact with biometrics concepts to then potentially fall under the statute. That can include real-time, I'll give you a practical component, real-time face scanning for purposes of determining credibility. I don't know, or real-time analysis of individuals in a room and how they interact with each other. There's a variety of potential vectors where biometrics and AI can weave together to create very interesting things. But that's where it'll be under the law again. So anytime, and the law just under Illinois is anything that's going to fall within that biometric capture is going to be under the law.
Right.
So it's not going to govern AI in general, but as AI involves a data collection of those areas, that's where the law will come into play.
Right. We cover often the proof of personhood emerging sector where people will scan your irises and then, create a hashed identity, unique identity or whatever. And that's that then gets sort of filtered through different servers, decentralized and attached to your wallet. And of course, they're all AI companies as well. So all of this does seem to be converging, and it'll be very interesting to see how what sort of complexity it adds to the legal landscape for sure. I wanted to ask, you ostensibly, if one of our, a relying party or provider, if a company gets in trouble, gets in some BIPA trouble, you're sort of the man to call. You're the Ghostbusters of BIPA lawsuits. Can you tell us what can businesses do to make sure they don't fall afoul of this law?
First of all, I want to say I really appreciate the Ghostbusters of BIPA lawsuits. I'm going to use that in marketing. That's fantastic. What we like to do is we're holistic with our clients, and so we talk about looking backwards and going forwards. Looking backwards is we have to deal with the potential liability and what that means, and going forward is we want to make sure that they're never in a situation where potential liability can occur, and that they can use these technologies in a way that is helpful for the business and compliant. I've always said to my team, we don't want to tell our clients don't do these things, like don't use the technology, right? Like if you're advising your clients to not be cutting edge, well, that's not the best. That's not the best thing for Illinois, and it's not the best thing for the clients in terms of being competitive. And so our focus is, how do we utilize this technology responsibly? How do we comply with the statute? And how do we ensure that we're covered while at the same time getting the full benefit of this technology? That's what we do for purposes of compliance on the look forward basis, and on the look back basis to handle litigation. We really want to understand the nature of where the plaintiffs are coming from, and if they have a good case or not a good case. And if it's a fringe type of case or one that we have a lot of defenses, we're gonna pursue that pretty vigorously.
All right. We're coming to the end of time, but I wanted to ask you, at the beginning, you sort of suggested that the biometrics is where your interest lies, that this is something that you pursue because it's fascinating to you. What is it about this world that has sort of made you want to dig in and become an expert in this sort of litigation?
I think it's the convergence between the benefits of new technologies and also their detriments and dangers. I remember my parents talking about this when I was growing up. I imagine that there are many households of people listening where you can remember the prior generation talking about some type of technology and the pros and cons of it. That's just the nature, I think, of societal evolution, is that we're going to be creating novel technologies that can have a variety of beneficial functions, but they also come at costs. There's certainly collections of data that can compromise folks, and a loss of privacy. And so how do you maintain that balance? To me, that's the forefront of civilization. That's where we are in terms of, as we march forward, how do we continue to march and at the same time protect ourselves? I just think it's fascinating. I think it's a wonderful place to be in.
Excellent. Well, I'll ask you my last question then. You're in Chicago, that's correct?
Yes.
So Cubs or White Sox? That has to be the question.
Absolutely Cubs, although I have a lot of respect for the White Sox, but my grandfather got me in early on the Cubs, and go Cubbies.
Thanks so much to Daniel Saeedi for taking the time to talk biometric law with us today. And thanks to you for listening. For all the latest developments in biometrics litigation, legislation, and innovation, be sure to visit www.biometricupdate.com.